Morning, everyone, and welcome to our session on POPIA and specifically dealing with direct marketing issues that is very real to daily practice for any business. My name is Maryna Botha. I'm an executive consultant with STBB. I'm based in our Cape Town office. We had rain this morning. The rain has dissipated, but let's see what happens. We've got a rainy day ahead. I hope that the presentation isn't that rainy and that it gives you some guidance on how to go about the requirements and the regulator's latest notes on direct marketing specifically. I'm going to go over now and present from a PowerPoint. You are welcome to interrupt me as we go along with questions, but I thought that because of the highly technical nature, especially when we get to the discussion of what constitutes direct marketing, WhatsApps, telephone calls, email, group emails, getting information from Facebook and the like, those get very, very technical. So I thought it's perhaps best if you would post your questions in our chat box on the side, and then the marketing team will collate those questions. I will provide answers, and then when we send you a recording of the webinar, we will then provide you with the suggested answers to those questions. So please feel free to pop into the chat box questions that arise as we go along. And I will make sure that we answer them for you. I'm going to start screen sharing, and then we can jump into it. Okay, just to give a summary of what I plan to discuss this morning and what we would like to address is just to get a grip on who must be compliant with POPI or the POPIA. I prefer the wording the POPIA because it's the Protection of Personal Information Act, but people also refer to it simply as POPI. What are the main compliance tick boxes for you as a business? What you really as a minimum must have in place. And then I just want to highlight how busy or not busy the Information Regulator has been, how much there's intervention from the regulator's side, what does the penalties look like, and so forth. And then we go to the difficult and very tricky aspect of marketing and the Section 69 of the Act, what it allows you to do and what it doesn't allow you to do. Specifically, I'll go and chat about the use of telephone calls, emails, and other electronic communication methods. And lastly, I'd like to touch on lead generation, what your obligation as a business is if you use the services of a lead generation service provider. So let's jump into it without further ado. When or to whom does the Act find application? Now, the Act is very broad, principle-based Act, not so much a rule-based Act, but a principle-based Act, and it works with definitions of personal information and processing and responsible party. Those definitions are exceptionally wide. Personal information is generally anything that can identify a person. It even goes as far as including your religious beliefs, your political beliefs, and your sexual orientation and the like. All of that is regarded as personal information. So as soon as a public or private body process that information, this Act becomes applicable. The word processing in the Act, in turn, is described exceptionally widely. It deals with information that you obtain, the way in which you obtain it, what you use it for, where you store it, and how you delete it. So it is, in a way, the whole life cycle of information. Firstly, when you get it, where do I record it? On paper, on a computer, on a cell phone? Then where do we store it in the long run? And when do we delete it? And did we delete it in a safe way? Processing encompasses all of those things. So it's exceptionally wide. It's anything and everything that you do with personal information, or what we just generally refer to as data. But in this context, obviously, data that relates to individuals and or the data of entities. Responsible party is the person collecting and processing that information. So if you have information, you work with it, you use it, you are a responsible party, and you are therefore the one who is obliged to comply with the provisions of the Act. Why do we have this Act? And are we very just over complicating life for businesses out there? No. We've got a person has the right to privacy. You have the right that people don't have your detail or use it for reasons that you didn't give consent to. And in other words, this Act is an enactment practically of my constitutional right to privacy contained in our Constitution, and the Act just gives body, life, and form to that human right that I have, and that comes from our Constitution. It's not a South African only thing, it is worldwide. You have legislation that deals with privacy protection, and some of them are way stricter than ours. There's a lovely expression in the French law. They call it le droit à l'oublier. That means I've got the right to be forgotten, and that is the right to privacy. I've got the right that people forget about me, that they don't know about me. And that is what our Act and international legislation is all about. Okay, having said that, what does our Act prescribe? It doesn't say that you may not use information. It doesn't say that you may not process data, but it works on a principle basis, and it says that there are 8 conditions of processing, in other words, of using data. And these processes are, the conditions are, I've listed them there for you. I can't discuss all of them. It's loads of sections in the Act, but I just want to briefly touch on them, because as we go along, we will need to refer to these conditions of processing, and that you just know what we are referring to. Now, the first condition, accountability, simply says you are a responsible person because you collected the data. In other words, you must give effect to the 8 conditions. Then you've got condition 2, processing limitation. It simply states you must process personal information lawfully in a manner that doesn't infringe the data subject's privacy. It provides for minimality. In other words, you obtain only so much data as you really need, and nothing in addition. And in that regard, I can perhaps just give you an example. Many buildings, if you enter that building and you have to sign in a register, they often ask you for many details that really isn't necessary. They might ask for your name and a cell phone number, and when you get in there, for security purposes, and if there's a fire, that they can check that everybody has left, that they can contact you. But if they start asking where you're from, what your ID number is, or address, or other details, that's unnecessary. So processing limitation or minimality deals with instances like that. And then section 11 is the very important one in condition 2, and that's the one that gives you certain justifications for collecting information. The one is if you've got the consent of that person, and the others are if there are other justification reasons. For example, it's required by the law, or it's necessary to protect your interests, and or that it's necessary for pursuing your legitimate interests, you as a legitimate, as a responsible party. And I will touch on that a bit later because it impacts dramatically on your rights to do direct marketing. But just remember that that is part of the condition 2, processing limitation. You need consent, but there are other justification grounds. But that's not all that the Act says to us. It says, okay, the first one, you're accountable. Second one, there's limitations. Third condition is purpose specification. That simply means that the documentation that you process, that you collect, that you use, that you store, that you delete in the long run, it must be processed for a specific and explicitly defined lawful purpose. So again, and I'll touch on this later, once you've got a marketing plan in place and you decide to do certain forms of direct marketing, you will have to list your purpose specification of collecting that data, how much you're collecting, what the purpose is, and the like, because that is showing compliance with the conditions of the Act. It also says under purpose specification, section 14, you mustn't retain information for longer than you require it. Unless there's some other law that says you have to retain it for a longer period. For example, in terms of FICA, you have to retain records for 5 years. For ourselves as attorneys, we have to retain certain client records for 7 years. So the law might come and ask you to retain it for longer, but otherwise you're supposed to hold onto information only for as long as you need it. Then condition 4 relates to further processing of information. Simply it says, if you collected information for purpose 1, to market, for example, a property on behalf of a client, you may not now use it to sell other services to that person. The specific consent for which you obtain the information, that's what you may use it for, and not for other details. Then condition 5, information quality, that deals with the correctness of the information that you have in your systems. You must take reasonable steps to ensure that the records that you retain are accurate, not misleading, and are updated as necessary. And then we've got condition 6. It's called openness. It means you must maintain documentation of your operating processes. And if someone wants to have access thereto, or specifically the data subject, the person to whom that relates, you have to give him access and status. And this is what I have, this is where we obtained it from, and this is where it's stored, and this is whom it was shared with. Then condition 7, your security safeguards. It obliges you as a business to have reasonable technical and organizational measures in place to prevent loss, damage, or unauthorized destruction of the personal information. You must identify foreseeable and likely risks and deal with them. And it obliges you, if you share your information with a third party for a specific purpose, for example, you employ a third party to pay salaries of your employees, you have to have an operator agreement in place in which that operator undertakes to deal with that information in a way that is compliant with POPI and in a way that you prescribe. And then lastly, 8, my data subject participation. That simply means the data subject, the person to whom the information relate that you have, must be given access to correct the data if necessary, and may ask you to delete it if that is the request, and obviously if you're allowed by law to delete those records. But that basically is the principles on which any processing, including marketing and including internal business operations, have to comply with. when we go on to our next step and speak a little bit about the basic tick boxes that must be in place when you do when you attend to the compliance with POPI, obviously everything we say must be measured against these conditions. You need to prove to the regulator that in all your processes, you've complied with the 8 conditions. So let me see, let us have a look at what the main compliance tick boxes are for a business. As a starting point, you have to appoint an information officer. This person is either your CEO, or by default, it will be the CEO or the business manager. Otherwise, a senior person specifically delegated to fulfill this role. This person must be registered with the Information Regulator. You can go on their website. There's certain prescribed forms to fill in, and you register this person with the regulator. Just on a side note in this regard, often I have clients who phone me to say, listen, the regulator sent so-and-so note. I never got the note. And often the reason for that is because when initially the business registered their information officer with the regulator, they gave a particular individual's email address to receive emails, and when that person left, that email address was never updated with the regulator, and you would then not have received the emails. So make sure that whatever information you've recorded with the regulator is updated so that you do receive communications that come from them. In any event, it's just a very, very good compliance mechanism to keep in mind. Then, in order to comply and make sure that you are in your business compliant with those 8 conditions that we listed, that you've got the security, that you collect it for the correct purpose, that you destroy it when you're supposed to destroy it and not retain it for longer, you need to know what it is that you hold as personal information, where you collect it, where you store it, where you use it, when and where you delete it. So we speak in compliance talk. You'll ask your client to do an inventory of the personal information that is processed within that business. I get it by a telephone call, email application, from a website, or the like. We use cookies. No, we don't use cookies, but that is part of establishing that inventory. And then you draft and then implement data protection policies. In other words, you will draft a document that refers to those 8 conditions, and you will say, in my business, I collect it in this way, I deal with it in this way, I'm compliant with condition 1, 2, 3, 4 because I do the following. So you draft data protection policies, and then obviously you need to implement them. For sending mails, for communicating clients, make sure that you've got consent. Consent in they call in academic circles, even though they call the consent the golden thread that runs through POPI, and it is a little bit of a golden consent. Once you've got consent of a client, you can obviously contact that person. Without consent, there's loads of loopholes to jump through, specifically in the realm of marketing. But you need to also record your processes in respect of obtaining consent, because that is part of compliance with that condition 2 stipulated in the Act. If you use any of the other justification grounds that I've said exists under Section 2, for example, I'm using this data because it is in my justifiable interest. I need to have a recordal of I've collected it in compliance with Section 2. Condition 2 is justification. Why? Because it's justification for my business to do X, Y, and Z, but it has to be recorded then in your privacy documents. And obviously, then you must continue to comply also with 3, 4, 5, and 6 and all the other conditions. Then ensure accuracy, as we've spoken about. Do as much as you can to make sure that what you have recorded is accurate. You must list and record what your retention limitations are, and in other words, when do you store it, for how long do you store it, where do you store it, and then when you will delete it because it's beyond its retention period. Security measures are important, access to your data and the like. Hacking, that's a real problem in general business life. So look at your security measures and implement something that is reasonable. You need privacy notices. What is that? It's a notice that is available to the public, often on your website or an email signature, just saying view our privacy notice here. And that's a notification to the public to say, listen, yes, we take your personal information seriously. We take the POPIA Act seriously. This is what we have in place to protect your data. If you have a query, contact X, Y, and Z at our business. There must be incident response processes. So if something goes wrong, if you're hacked, if information is leaked in any way, you have to have a process that will kick in immediately. For example, your IT department manager will investigate. They will try and see if they can contain it. In some instances, you have to notify the regulator thereof, but you have to document that. Maintain records of what you do, especially we're going to speak about direct marketing just now. Maintain records of the type of direct marketing, where you got the info from, what you're using it for, and how you are complying with the 8 conditions. The regulator doesn't want to see a document that was created after you've done the direct marketing. It must happen before you do the direct marketing. And then obviously, just for good business practice and ethics, conduct regular audits, make sure that your systems are working and that you are working in line with your own privacy policies. And then the good news is that the Act all throughout the provisions indicates that you must do what's reasonably practical in your circumstances. So if you're a smaller business, you cannot necessarily do exactly what large banks would have in place, because they are large businesses with large turnarounds. They can appoint expert personnel to do their security measures, for example, but you must do what's reasonably practical for you to do in your circumstances. So make sure to implement a system that's adequate and is the best that you can do at that stage. Then also, POPIA manuals are very, very important. They've progressed over the years. The POPIA manual is a little bit the other side of the coin of POPIA, because POPIA says you as an organization hold personal information. You may not share it because it's personal. You must deal with it in a certain way. And then POPIA is the Promotion of Access to Information Act. You must have a POPIA manual as a business that must also be made available to the public. And that's a document in which you explain to the man in the street that if he requires information that you hold as a business, which is actually private information, that in principle, under the POPIA, you're not allowed to share, how he can access that. That person who wants to access that obviously has to prove that he needs that for his legitimate purposes of promoting an action in a court, for example, and then you receive that application and make a decision, yes, we're going to release it or not. POPIA is on a technical point of view and from a legal point of view, very, very complex. It's definitely not a simple issue to obtain access of records from an institution, because the institution has to comply with POPIA and keep it private. And there's loads of court cases dealing with instances where a organization had refused to give the information, but yeah, that's a different webinar. Just remember that you are supposed to have a POPIA manual as well, where the public then has a access to knowledge as to how they can access the information that you have that is otherwise private, and the process to follow. Okay, let's look at what the regulator has been doing. And on this note, we had a smiling customer as on the image on the left-hand side of the screen. Why? Because the regulator has been fairly quiet. Unlike what accountable institutions would have become used to, the FIC, who's been very, very busy and who's doing inspections and interventions and issuing fines. From the regulator's point of view, it's been fairly quiet, for which I suppose one is fairly thankful at this stage. Apparently there are some financial constraints there, so they are not in a position to institute legal steps against entities. There's been one or two matters that actually went to the court on severe breaches of the POPIA Act, but generally it's been few and far between. The media incidents, though, are obviously of concern, because if you are listed in the media, and that happens quite a bit for non-compliance, or your records were made available, and you didn't have adequate systems in place, that media negative publicity is a nasty thing. It is really not something that one wants to face, so you will be careful to try and comply with POPIA as much as possible, whether or not the regulator is busy. And just for interest's sake, earlier this month, the regulator received a proposed code of conduct from the residential community industry that deals with how personal information will be processed in the residential community sector. The NAMA, I know, is also part of that application. It would be interesting to see what comes out there. And if ever you want to have access to these documents, please follow me, contact me directly or otherwise on the compliance email address that we have at STBB, which the marketing will put into the note box at the end. But it's from that email address that we address compliance issues for clients. There's also been regulations to the Act, recent amendments that became effective on the 17th of April this year. And as with everything from the regulator's side, it's very, very pro-consumer. So what she did in these regulations is just to advise consumers and give them more assistance in how to make complaints, how the complaint form should be set out and the like. So bear that in mind when you plan your POPIA compliance within your business, that if issues land on the desk of the regulator, they tend to go very, very pro-consumer. I'm not saying it's illegal. I'm just saying it appears to be very pro-consumer. Okay, let's look at section 69 of the POPIA. That's the one that gives one lots of gray hair. In principle, section 69 deals specifically with electronic direct marketing, and in a way, it is a ninth condition of processing of information. We spoke a little bit earlier about the 8 conditions of processing. In other words, all the requirements you must comply with when you deal with personal information in your business in any way. But you must add a plus. If you want to do direct marketing electronically, you have to comply with section 69, and section 69 is not always easy to comply with. The definition here is quite important. Electronic communication in the Act is defined to to specifically deal with text, data, voice messages that are stored on a recipient's systems, and that is therefore is considered to be electronic communication. I deal with that a little bit more in my next slide, so I won't go into that too much now, into that definition. But where Section 69 does not apply is where you approach a person in person, letterbox drops, or where someone approaches you for assistance or information. Obviously, that's not even direct marketing. And if they approach you, and if you do letter drops or you approach someone in person, that's personal direct marketing, but it's not electronic direct marketing. Now, in Section 69, as soon as you do electronic direct marketing, the section makes a differentiation between someone who's a customer and then someone with whom the business has had no dealings before. If someone is a customer, in other words, someone with whom you've had dealings, you've had engaged, that person has engaged with your business, you may electronic direct marketing to them, provided that there is an opt-out, always to say, listen, I no longer want to receive any of these email messages from you or other direct marketing methods. And the direct marketing that you've sent to this existing customer is aligned to the consent initially given. So if I'm Pick n Pay, and I send you continuous emails about specials, that's fine. If I'm Pick n Pay and I send you details about my attorney services, then obviously it's not aligned to the consent Pick n Pay initially received, and that would then not comply with Section 69. Remember also that the consent we speak of in this POPIA Act is exceptionally tricky consent to get, and perhaps laughable to a certain extent. It's good, it's beautiful that they say the consent must be voluntary. Of course, it must be specific and informed. So a person must really know what he is consenting to, what he is likely to receive, and then say, yes, I want that. So that part is good. But what happened is that the legislator, when they passed the act, they included the Form 4, which is your form for obtaining consent from someone for electronic direct marketing. In other words, consent in terms of Section 69 of the POPIA. And that form is cumbersome and not practical. It really isn't practical. I have a colleague in the compliance industry who wrote an article recently, and on a tongue-in-the-cheek note, but on a very valid note, she made the point that if you were trying to comply with Section 69 now, so you have a telephone number, you call it, now you know you need to get the consent, so you read through the whole of Form 4, and you record the fact that the client said yes, 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 yes. That would take you up to 4 minutes. It is so impractical as to be almost stupid. It's just not workable. So hopefully, and I'll touch on that again in the next slide, hopefully the regulator or the South African Direct Marketers Association will take these aspects to court very, very soon so that we get clarity, and so that one can deal with these very impractical aspects of the Act's requirements. Just to touch on the direct marketing aspect, I'm a person who likes to argue, but subject to various provisos, that you could perhaps send an email to a client that's not marketing. I'm not marketing my services as an attorney or as an estate agent or as a builder or as a whoever I am. I'm giving general information. For example, I send to my database or to a database details about the tax changes that was recently announced, or about rezoning in the area, and the like. Does that constitute direct marketing as such? Although of my services, although it probably isn't direct marketing, it definitely falls within that broad definition in Section 69 that says if you do direct marketing in a direct or indirect way. So the regulator would ask, why would you even bother to send this message if it wasn't to market your services in some other way? If you say, well, I'm providing a public service by keeping the public up to date, there's a reasonably good chance that the regulator or a court would struggle to accept this justification as is, especially not if you also add at the end, I do so and so, contact me for this service and the like. So it is a bit tricky to get out of that one, but you probably could make an argument out for the regulator to explain why you thought the one or the other. But to summarize, generally, if you want to send messages, direct marketing messages to anyone, you need consent, and you need to have a recordal of the consent, be it on paper, be it electronically, and just be very, very careful to keep record of how you obtain the consent, what for, what is your limitations. I mean, how did you comply with all the 8 conditions? Keep a record of that, in case you ever have a visit of the regulator, that you can provide that details to them. I also think it's very, very prudent to have a specific document or process in your business to deal with direct marketing, and that you say, this is how we comply with the 8 conditions, well, the 9 conditions, if you take Section 69 into account. This is how we comply with the 9 conditions. We do this, we do that, we do that, in respect of each and every telephone number, email address, and the like that you use. What I want to touch now on is the issue of lead generation. Okay, let me just touch a little bit on the telephone issue. Electronic communication and the limitation of Section 69 was, up until December last year, when the regulator issued this new guidance note, limited to stuff that are sent via WhatsApp, via email, and the like. It didn't include telephone calls. Why? Because the definition in the Act speaks of a text, voice, or sound that is stored in a network or in the recipient's terminal equipment, and the definition then, per implication, excluded telephone calls. Nonetheless, the regulator then issued this guidance note with a contrary opinion. This, despite academic opinion and the Direct Marketing Association of South Africa's submissions to the contrary. The point is that the element of storage required in the definition is absent in the case of a telephone call. And it's interesting to note that the Law Reform Commission specifically considered telemarketing and intentionally, before the Act was passed, excluded telemarketing from electronic communications. This despite, in this guidance note that the regulator issued, there's an express contradiction of the position, and she states that electronic communication includes a telephone call. In the same guideline, a rather disingenuous argument is made, and they argue that the current technology used in telephone calls automatically stores information, even if it is for a split second, and therefore telephone conversation is electronic communication. I disagree. POPI attorneys disagree. Academically, there's disagreement. The Direct Marketing Association of South Africa also disagrees. So we will see what happens in this regard. It's interesting to note, though, that the regulator has also recently sent further suggestions, draft amendments to the regulations to the POPI Act, to Parliament, and therein, again, they include telephone calls as electronic communication. This still has to go through the whole parliamentary approval process, but even if it is approved, a regulation cannot amend the definition in the Act itself. And as I've said to you, there's cogent and arguments in the industry that a telephone call is not electronic marketing, electronic communication. Nonetheless, it's a problem because this is not what the regulator's opinion is, and it might be cold comfort to say that we don't think her opinion is correct, because if you are challenged in terms of Section 69, by a data subject, and the Information Regulator chooses to make an example out of your business, then even if you are successful, there's negative impacts that you may suffer: the legal fees, negative publicity, uncertainty pending the outcome of the investigation, and then further scrutiny by the regulator of your practices. Nonetheless, telemarketing is critical. It's been acknowledged as a critical component of marketing and for businesses by our South African Law Reform Commission. So it's assumed and hoped that the Information Regulator, that the Direct Marketing Association of South Africa, DIMASA, will in due course, shortly, hopefully, address this by way of an action to court for explanation, for clarification. So one is holding thumbs for that. Now to go to my last slide, lead generation. There's two sides here. On the one hand, consent is always a requirement. As we've said, it has to be voluntary, specific, and informed. So if you use data that was obtained in this way, you got the consent, and the lead generator complied with all 8 of the provisions for conditions for processing, you can use the data obtained in this way. A data subject may still, when you contact him, inquire where you got the information from, and he must always have the option to unsubscribe, but in principle, you can use that. Engaging with a lead generator is important because at the very least, you need to obtain written confirmation from them that the details were collected in a way that is compliant with POPI. And I would include that you get a full and comprehensive indemnity, including fees that might be payable when the dispute arises, and not when it's finalized, but when the dispute arises, if there were any breach of POPI on the side of the lead generator. On its own, standing alone, this is a good test to see if your lead generator actually followed POPI, because if they're willing to sign a document like that and provide you with an indemnity, it means they were compliant. And just for interest's sake, it's not only here where it is so strict. In Europe, it used to be acceptable to have a good contract where there is a warranty and an indemnity provided by the lead generator, but this has now been amended Um, and it's required in Europe that the person making use of the lead generation services must be even more inquisitive. So you want more than a indemnity. They say the person receiving the leads or making use of that service must find out how and where the information was collected, what notices were issued, what the purpose was for which it was collected, were the data subjects informed thereof, did they have an opt-out at the time, and the like. So they oblige the person to inquire, make these inquiries from the lead generator. That's not something that we believe is applicable here yet, although the information regulator might in due course issue guidance notes in that regard, but that's not in place yet. However, if you use the services of a lead generation, make sure that you make certain inquiries and keep a record of the inquiries that you made. If there's no records, if there's no consent, if there's no privacy notice and the like, then you know there's certain red flags relating to the data that you receive from that generation services. The thing is, what now? What if you have data and your lead generator cannot give you that certification or that confirmation that you have that they've gone through the necessary processes? It simply means then that you have to go through that process. You are allowed to, for in condition 2, for your legitimate interests as a business to use data obtained and to then approach a client using that data, and provided you go through your other steps at the time. So when you contact someone from a number you got from a lead generator, where the lead generator cannot confirm that they've complied with POPIA fully, you may use that number, but you will have to obtain consent from that person when you use the number to continue marketing to him or her. And you obviously, in the same process, have to comply with the other conditions of harnessing information, of processing information. There's ways and means how to do this. You can't go through this 4-minute absurdity, as I've referred to earlier. And you have to have a plan before you start doing the marketing. You have to say for yourself as an entity, I'm going to use that number. This is how I'm going to comply with condition 1. This is how I'm complying with condition 2. This is how I'm complying with condition 3 before you do that marketing. And then when the regulator comes to you, you can justify how you complied with the Act in using that information. Remember, the onus of proof to say that you did it in a POPIA compliant way is on yourself. So you need to have those records in place to be able to prove that. And I want to end on that. I see we've been at it for quite a while and I only have 10 minutes left. So I'm going to touch on that last point there only, and then just remind you that please, if you've got questions, put it in the chat box. We will definitely respond to them when we send you the recording. And obviously, we run a compliance service here at STBB. You can contact us at compliance@stbb.co.za, and we can assist you with getting your processes in order. We're not the only firm, obviously, who does that. There's loads of specialists in the field out there here in Cape Town. Paul Esselar is brilliant. There's Novation Consulting, but make sure you work with a organization or a person who knows what they're doing. It's exceptionally important to be compliant, especially with direct marketing, because that's where persons tend to complain to the regulator. They don't like receiving calls, and they get very uptight about it, and you will face issues with the regulator. I've often assisted clients with that interaction with the regulator, and it's sometimes quite tricky. Okay, last note, as I said, using public records. Yes and no. You're allowed to use information that a person has made available publicly. For example, you go onto our website, you will see this email address, my email address, and you contact me on that email address, and your argument is, but I made it available publicly. There's a yes and a no there. There's a reason why I make my email address publicly available. That is so that we can render services. And similarly, most people, when certain of their details are made publicly available, there's a specific reason why it is so. So if you use that address, but you use it for a different reason, for your own direct marketing purposes, then obviously you face non-compliance with the POPI. But there is an argument to say that if your information is so widely available on social media pages and internet and the like, is likely to be picked up and used for direct marketing. So the regulator will perhaps take something like that into account. But again, when you get a complaint like that, and you did use an email address, for example, you use my email address from our website, and you use it for direct marketing, and I go to the regulator, I complain, then the regulator will contact you and say, listen, I don't like what you did. It's not compliant with POPI. And you respond, yes, okay, we know we did that, but this is how a direct marketing plan works. This is where we complied with condition 1, condition 2, condition 3, condition 4. Then you are very unlikely to be fined because they can see you've got a record of how you approach this. If you don't have that, then obviously you face problems. Okay. Thank you. I said it was lovely to have you all. I said in a conversation to someone yesterday that it was going to be a short seminar because I wanted to concentrate, mainly on the basics that you have to have in place to become compliant with POPI and then direct marketing. But I see we've run into 55 minutes. But thank you for attending, and I look forward to receiving your questions, and we will send you our responses and share it with everyone on this group within the coming week. Thank you. That's it from me.